So you had your visa application refused or cancelled, and you're probably wondering what are the next steps from here. In today's episode, we're going to take you through what is Administrative Review Tribunal, and more importantly, what happens if you can't afford legal representation.
So yeah, in other words, Ross, how to represent yourself before the tribunal. So we're going to be speaking about all the steps and give you tips on how to follow and how to arrive to the hearing. And yeah, do a good job.
Make sure you stay until the end to get those tips. Now, let's talk about what exactly is ART.
So the Administrative Review Tribunal, I must say that I actually struggle a long time to say this word or like this phrase.
Art.
But yeah, it is another chance. I like to put it this way: another chance for an applicant to say why they're eligible for a certain visa or why their visa shouldn't have been cancelled. The member of the tribunal is going to be looking at the application and your eligibility afresh. So you're going to have the chance to present all the reasons why you should get that visa.
Yeah, and that's really important. You sort of need to look at it as the potential last opportunity to be able to present your case and also provide any new evidence. So what we want to talk about is how do you start? You've got your visa application refused, or maybe your visa application's been cancelled. So let's talk about what happens afterwards. So first and foremost, you receive a copy of that decision record. It is paramount that you read that decision record because there will be certain things on that decision record that will indicate what you need to do. So for example, when to apply. In cancellations, it's a specific number of days. Refugee cases, migration cases.
So in this instance, let's focus on the Migration and Refugee Division. So that means those refusals that are around reasons out of character, not necessarily for character, but for other reasons. So like Ross was saying, it's important to take into account the time that you have to apply. So generally speaking, 28 days. Once a visa has been refused, you have those 28 days to make a decision to see if you want to appeal this refusal or prepare to depart Australia. So in this point, you're assessing the time that you have to apply. But I want to touch bases in that concept. A lot of people have of buying time.
When you lodge an application with the Administrative Appeals Tribunal, so maybe if we just go back a little bit, the notice does say you can lodge an appeal within 28 days. It's important that you understand whether there is a case to lodge. Yep. So to give you an example, let's say if you don't meet something at the time of application, and that's part of the regulatory criteria, lodging the application with the tribunal will get you the same outcome. So one of the things that we always encourage you to do is have a look to see how you can present your case differently. So we've mentioned how it's going to be a fresh set of facts that are looked at, but on that note, what's important to understand is that you need to understand what those new fresh set of facts are, and if there aren't none, or if there are none, it basically means that you don't have a case. And I suppose the problem with buying time is that if you get to a stage of where there is a hearing, the application could be dismissed, and that could be an issue for you as well in terms of having additional bars placed on your visa and just being able to remain in Australia. So it's not always a good option to apply to the ART. It is an option, but it shouldn't be used as a first option. There might be other options.
Yeah, and also you have to think about the cost. Is it cost effective for you? Because you're going to be spending time on the application itself, and in circumstances where, for example, it is a student visa refusal, then you have to consider the costs associated with the courses you're choosing. And so is it actually effective for you? Is this actually the right choice for you? This is the things that you have to consider.
Yeah, and just speaking on student visas as well, a really good example that springs to mind. Let's say, for example, you have your student visa refused and you're now on a bridging visa A with the ART. The course finishes and the case is still before the ART. You can't get your 485 visa because you're Section 48 barred and you're on a bridging visa A. So essentially, you've sort of wasted that time and that opportunity, and this is why you really need to understand why you're lodging the application and think about all the alternatives, because it will come to a point of where the course has finished and you don't have a confirmation of enrollment to continue with the course. Okay, so we've got the 28-day rule. What exactly is the 28-day rule?
So this is a specific time that you have to make the application for appeal. It is not to be missed because this can cause your application to be invalid. And what happened there?
It gets dismissed.
Yeah, it gets dismissed. So you literally miss your chance. So we really recommend looking at your dates and not leaving things at the last minute because, we're humans. Mistakes can happen. And if you miss for one day, that's it.
Yeah,
no more chances.
Exactly. It's unfortunate that there's no provision in legislation to lodge the application on the 29th day. There's been cases challenged at the court about lodging the application sort of subsequently, and they're generally not successful.
Correct. So now you made the decision to appeal. What happens now? It is important to bear in mind that now the tribunal, the Administrative Review Tribunal, has the direction to provide what is called the preliminary submission. So Ross, what is this first submission we'll have to provide?
So this new tribunal commenced on 14th of October, and there's a few differences between the old tribunal and the new one. The main one is that when you lodge the application, you have to provide a statement of facts as to why you're lodging the application, and this is something that wasn't required under the previous regime. So say, for example, if you lodge the application and pay the fee, the application could be dismissed by the registrar, which is sort of your support staff, and it could be dismissed based on the fact that it's incomplete. So it's important to provide a statement of facts, issues and contentions as to why you're lodging the application, why you disagree with the decision. To make it very clear, you're not putting forward the entire case, but you need to put forward some reasons as to why you're lodging the application.
Does that mean that if somebody was applying to buy time and there was this applicant does not provide this preliminary submission, can that then be dismissed?
Yeah, it can be dismissed, and further, the tribunal can actually make a direction to ensure that you don't try to reinstate your case. So it's actually covered in the Tribunal Act. If, let's say, your case gets dismissed, there is a mechanism for you to reinstate the case because maybe you were sick or there's some compelling reasons why you couldn't provide that. But if in the absence of that, the tribunal can say, don't lodge any further applications. And then that pathway is closed for you completely. Yeah. So I suppose it is important to, again, really take those 28 days, those 4 weeks to think about whether there's any chance. And like I said, if you've missed something that's a critical document and you can't really reverse the situation, so if it's a time application criteria, then no preliminary submission will be able to assist you.
Yeah. And this preliminary submission must be submitted at the time of the
application, yeah. So it's sort of, I suppose when you look at the new regime, it's kind of like a double amount of work. You have to do a smaller submission at the start, and then you do your larger submission when you get a hearing date. So it is essentially 2 submissions going in, not one like in the previous regime where you lodge the application, you wait 3 years, and then you lodge something. And if the tribunal thought there was an issue with the case, the member would need to hear it. That's no longer the case.
If you are to define what is this preliminary submission, what is in there? What must contain?
Yeah. Well, there needs to be a logical argument as to why you've lodged the application. So there's no particular template. You can't download, I suppose, a sample from the ART website, but it should articulate what regulation you disagree with. So let's say a student visa was refused, what regulation you disagree with, what more evidence you're likely to provide as well, and reasons why you think the decision's wrong. And it needs to be legal reasons as opposed to the fact that you're just not happy with the decision.
Of course. So, excuse me, at this point, it's like raising your hand and say, hey, I actually agree, I actually believe my visa should have been approved because A, B, and C.
Yeah, so a good example would be, let's say, a student visa gets refused, and it gets refused on the basis of financial, not being able to provide financial funds. But you might have provided a bank statement, maybe other documents, and none of that's mentioned in the refusal record. So you could mention that all of that's been provided, but it just wasn't looked at properly, or that it's not mentioned in the decision record. So that would be sufficient. That's the sort of information that you want to provide. But I think you just need to be very careful. If, let's say, you've provided financial documents and the case officer says, well, it doesn't meet the requirements, you can't go back and say yes it does because it's already been assessed. So you're kind of looking to see if there was anything that was missed, and it can happen in certain applications.
I want to dive a little bit in some tips and also what happens between that time of appeal application and the hearing, because like there's going to be some time, some waiting time. Can be months, can be even years. We have seen in practice. And what happens now? I think it is important to speak about this because some people tend to relax too much and sort of forget about that application. But I believe there is also a preparation process, and it's very it's very convenient for you to prepare because you're going to be speaking for a member one day, and if you don't know your story, then you're going to have an awful time at the tribunal. And that's the first tip: know your story.
Yeah, and look, that's a really good point that you've made. You've got a year to basically get all your facts together. So rather than kind of sitting back and thinking, well, I don't need to worry about this until I get a hearing date, this is a great opportunity for you to get to know your case. Maybe seek advice. We are talking about self-representation, but maybe this is a good time to actually seek advice to see whether you're on the right track in order to lodge your application. Legal representation is expensive, but just to check to ensure that what you've lodged is correct, because you might get a few tips in terms of how to strengthen your case. So you might know it, but you might get a few tips in terms of what else to submit. So that's really, really important. And gather all of the evidence as well. Because you only get, when you get the preliminary hearing date or a hearing invitation, you only have 28 days to put everything together, which sounds like a lot, but if you haven't done anything in the last, say, a year or so, it might be difficult for you to find those bank statements, find character references. It just depends on why the visa was refused as well. Yeah, so it can be difficult.
And remind me of cases that we have seen, for example, if you're making a claim of an attack that you suffered, if it is a refusal on a refugee visa, a protection visa, then perhaps you have to contact the hospital back home and get a copy of that medical report. So for every claim you're going to make, you have to have a document proving that, because there's nothing a member or anyone can do if you're telling a story but nothing to back it up with documents. It sounds pretty logical, but we've seen cases where...
100%. And look, it's not like the courts where... in courts, anything that you say is evidence. In the tribunal, anything that you say supports your evidence. So if, let's say, going to the protection visa and say that you suffered an attack, and as a result of that you end up in a hospital, in order to have any weight of that claim, you need to provide hospital records. So if you don't have that, then what you've said essentially will not be taken into consideration. But what's a shame about that is that an attack might have happened, you just haven't had time to provide those documents because you didn't think about that.
So it is crucial to take this time and prepare.
100%, yes. The other important element that you want to do is you want to do a little bit of homework and understand what exactly your visa actually entails. So say, for example, you applied for a refugee visa, you need to understand what exactly is being assessed. So, for example, you've got your protection obligations, you've got your complementary obligations. You need to understand what that is, because what tends to happen is that maybe there is fear of persecution, but you might not understand actually how to present that. So what you should be doing is really understanding the purpose of your visa and trying to understand why that visa was refused at the Department of Home Affairs stage, because clearly something that was provided wasn't sufficient, and that's how you ended up at the ART. So one of the things that I would recommend doing is, whilst you're waiting, which can be quite an anxious time, do a little bit of homework around what your actual visa allows you to do and why you applied for that visa, how it's assessed. There are certain legal terms which can be a bit difficult to interpret, but because you've got that time, this is where you can go away and just do a bit of work. Where we see cases, self-represented cases fail is where, let's say, a refugee applicant may have a legitimate claim, but the way that they put their claim forward is not as per the ART directions. So basically they're saying that they fear for their life. There might be actual well-founded fear, but it's not articulated as per the law, and the visa fails, even though the person has a claim. Unfortunately, law is not about being just and fair. It's about following specific regulations, and if you follow the regulations, you get the visa. If you don't, then you don't get the visa. It has nothing to do with being either right or wrong.
Let's speak a little bit about the submission. What the submission happened and what is the structure that we recommend following. So, first of all, statement of facts.
Yeah.
What happened from beginning to end. So it is important to provide the tribunal with all the points that have happened, all the journey you've been through since day of arrival to Australia, the visa you have held.
I think it's also really important to keep in mind that your submission is not evidence. So, for example, if you write something, that's not the law. So the purpose of the submission really is to tie up your documents. So say, for example, going back to protection visa, you've got 10 different documents. So in your submission, you want to address why you're lodging these documents and what they mean. So you kind of, well, almost like what you said, you're creating your story, right? And the submission ties everything together. But because it's not evidence, you have to have that evidence. So you can't say that you were attacked and you went to the hospital, but you have no hospital record.
Yeah.
So you can write about that in your submission, but it won't be accepted as evidence unless you've got those hospital records.
So then you have stated the facts. Now you have to also saying that you have to present the law. What is the applicable law in your circumstances? For example, again, if it is a protection visa, then you have to quote all the eligibility criteria for a protection visa.
That can be a little bit challenging if you don't know what those protection obligations are, because a lot of the time in protection visa cases, people argue about being scared to go back to their home country. But again, you need to address the obligations that Australia has. So being scared to go back to a particular country is not an obligation to give you a visa. You need to put that into evidence of why you're scared to go back to the home country. You need to provide a story behind what happened, so give a few examples, and you have to be able to articulate that. If you have no idea what those protection obligations are, the tribunal is unable to help you. They can provide you with a copy of it on the day. It's a bit like, you know, being provided something in a different language when you can't read it. It's useless to you.
Yeah, so it is important to know the definitions. Like you're saying, protection obligations. What are the protection obligations? It is good that you know it, because if you're going to say in the submission, okay, this is the relevant law, this is the relevant definition, protection obligations, if you don't know what that is, you won't know how to apply that to your own case and circumstance. And that's when you were saying, then they're going to say, okay, you're not applying correctly. It's not only about knowing what happened, but also how the law will apply to your case. So now when we have exposed what is the relevant law, then speak about how this applies to you.
And that's so important as well. And I think what's really important to keep in mind is that no case is going to be perfect. So you're not, let's just say there's 10 elements that you need to address. Not all 10 will apply to you equally. It'll be, some will apply more, others will apply less. And you need to be able to address that. So say, for example, a particular obligation may not apply to you, so you might want to focus more on another obligation.
Yeah.
So it's not necessarily the end of the road, but what's important is that you don't veer off and start talking about something that's not relevant to your case. And we have seen that happen before, because you've only got a certain number of hours at the tribunal, which sounds like a lot when you say hours, but it really does fly. And then before you know it, what happens is you just run out of time. So if you haven't gone through everything, you haven't presented your case.
The next step in the submission, we're recommended to be, say why you disagree with the refusal. Make bullet points. And for each bullet point, say why you actually believe you're eligible for this specific visa.
Yeah, exactly. And it's important that you keep it objective. So saying that the case officer was unfair, or they didn't know what they were doing in terms of assessing your application, is really unhelpful. So you kind of, you just need to remember that the tribunal isn't going to be looking at whether the department made an error. What they're looking at is a fresh set of facts that's before them, and they'll make a new decision, which could be the same as the previous decision, or it could be different. So sometimes arguing that the department didn't apply a particular law correctly may not necessarily be helpful, because that's not what the tribunal's looking at. They're looking at the fresh set of evidence. So think of it as a second chance to present your case without actually having that case being heard before by the tribunal.
Summary and list of documents. So obviously you're going to be summarizing everything, which sounds logical, but it is important at this point to say why you should have gotten this visa in a summarized way. And then list all the documents, very importantly, list each of the documents you're providing to prove all your allegations.
The tribunal website has actually really good videos in terms of how to collect your documents, and there's what's called practice directions. So it's important that you don't just email the tribunal sort of random documents. They send them 40 emails with different attachments, because they're not going to make sense. There's a particular way that you provide documents, and what may happen is if you don't follow that particular way, the documents may be missed, or the submission may actually be dismissed altogether. And generally it has to be one PDF document in a format where it's bookmarked, so the tribunal member can actually go to that particular document. So that can take a little bit of time to do, actually quite a lot of time to do, but providing each individual document without any context, it's not going to be very helpful for your case.
Yeah, you're going to thank yourself for spending this time and bundling everything. And actually, we've seen cases where the members, they say, hey, thank you for providing this good organized submission, because it makes it easy. It makes it easy for them. Remember that they are looking at your case and you want them to consider the document you have prepared in a logical way, so you maximize the chances for a positive outcome.
Exactly. It's a bit like, if you're working on a desk and there's a pile of documents everywhere, you know that document's in that pile somewhere, but you need to find it. But if something's neatly laid out for you and it's labelled, you can just pull up that document, and it's just a bit more pleasant as opposed to frantically trying to search for a particular document.